Hopefully we're live. I think we are. I think we're live, baby. I think we're live on this lovely Thursday. It is a lovely Thursday, I will say. Y'all welcome. Y'all welcome. Tap in. Thank you for being here. Of course, I am Cameron. This is Power Inherent in the People, where we the people learn about our inherent rights, those natural, none that were given to us, but those that were guaranteed from our great creator and secured by those, our ancestors before us, who fought for our freedoms to ensure that we could live like free. That's a thing these days, guys. Good afternoon for some of you. It's still morning for me. What's up, Jay? What's up, Ray? Ray and Jay. Ray and Jay. You know what I'm saying? Ray J or Jay Ray? I don't know, man. Y'all top in. I'm gonna wait till we get about I guess my likes show pretty good, but I'm gonna wait till we get to at least 10 likes. Yeah, whoever nine's in here, yeah, you're gonna have to go like. And we need to get at least 20 people in here, hopefully, before I start this up. God bless you as well, Jay. What's the matter? What's the matter, you? Well, I be seeing what's the matter in everywhere. What's the matter be in everybody's chat, bro. This dude has got to be a encyclopedia of knowledge when it comes to police interactions, rights, the right to try. I mean, I see what's the matter everywhere. It is insane how much I see what's the matter. Thank you for being here, what's the matter, because I know you got knowledge. I know you got it. Y'all tap that like button. Come on, we got to get some more people. We about to start it up. I don't know if this will be the last hour or two of this right to travel thesis that we have been going through, but y'all know this has been great. You can't say it hasn't been. And all I can say is we need to get this bad boy finished, because I'm ready to move on to some more things. But then again, I want to make sure that, let's see, always show sidebar, take that away. Okay, good. And then kind of scroll up and we be where we're supposed to be. Uh-oh. Let me come down. I got to figure out where we're supposed to be, y'all. Oh, yeah. Okay. Yeah. We're supposed to be today on the anatomy of traffic infraction. Y'all got the likes up a little bit. I don't know. Someone took their like away, but it's all right. It's all right. So we're going to do an entire screen share. Uh-oh. Let's get it going. Again, I want to welcome all of you for being here. I want to thank you all for being here as well. You beautiful people are what make this nation great, because of your understanding and knowing that we are truly free and should never be regulated, because administration of a free man is repugnant to his freedom, right? So I got my joint. I got my coffee. Let's get to it. So the anatomy of a traffic infraction. Let's look at the anatomy. We're going to break it down for real. Let's go. One more cough. Two more. Okay. One might be wondering where it is written authority for the police power to be executed against a personal, private traveler. Guess what? Nowhere. Nowhere is it written. It's not written anywhere that one has more power over you. The threshold of the police power, at least as far as statute traffic regulations are concerned, is the public enterprise and businesses. Public enterprising businesses. This is so huge because we've already gone over it in these earlier episodes of the most sacred liberties, your right to locomotion, that when you enter into a contract, whether it be for registration, you're entering into a business with the state, thereby giving them co-ownership, a security interest. Initially, in this section, remember that possession of a driver's license and a vehicle registered to the state is a public benefit of business grant from the state. It is a privilege. There's no doubt about it. What is the point of challenging a traffic infraction? Perhaps even to challenge personam jurisdiction or subject matter jurisdiction. What of an effort to challenge the facts that gave rise to the infraction? Perhaps a challenge that the infraction failed to give notice. A citation by definition is a command. Let's hear that again. A citation by definition is a command. Who can command you? You gonna allow somebody to command you? By way of writ, from an agency head or a policy dictate. Again, remember that from an agency head, corporation, sometimes issued by a court to compel an officer of the court to do a thing. We're not officers of the court, are we? Have you learned about definitions to understand what an officer of the court is? An arrest warrant is a per se citation. The traffic infraction issued by a policeman is a violation of the separation of powers doctrine. Let's get to depths now. Let's get to advanced legally scholarly depths. The traffic infraction issued by a policeman is a violation of the separation of powers doctrine. Just like for real, there can be no titles of nobility granted for real, for real. If you didn't know about that, that's in the right to travel course. We go over that in relation to our abatements, our memorandums that we file. A court is only supposed to resolve disputes and settle claims between litigants based on the facts brought by either party. So, as it pertains to a traffic infraction, the judiciary has stepped across its actual boundaries and issued a citation commanding the executive branch to use the court's format for an infraction notice, whereby providing to the executive branch a pleading document intended to perfect judicial appellate jurisdiction. Intended to perfect the judicial appellate jurisdiction. What's up, Jason Davis? I see you in here. What's up, Paperwork Ancestry, excuse me. I got a case. Let's listen to this one real quick. So Paperwork just said, Ancestry just said, I got a case dismissed by not pleading at all. I got to continue to the next day and went back and they would not let me in the building and handed me my dismissal paperwork. And this was a no driver's license. Ah! They love to get them dismissals out when you won't plead and you won't understand and you won't sign, but you can comprehend what they're trying to say. They love to drop it. Hey, congratulations, Paperwork. I love it. What's up, a pig's daughter? All right. As it pertains... Oh, we went through this. Pleading a document to perfect. Yep. The executive branch citation, aka traffic infraction, is an executive branch citation, which on the reverse gives the option to appeal the infraction to a lower court. 2. The appeal to a lower court is descendant of an executive administrative action. What's up, my boy G? We getting into them deeper ones. See, y'all thought I wasn't going to get there. You thought I wasn't. I told you we're getting to it, guys. Calm down. Let's get them likes up. We got 21 of y'all in here. Let's get it up. So, as citations go, look to infraction rules for courts of limited jurisdiction. Okay? Listen here, guys. I know you see it on the screen. Look to, search it up, all of my beautiful people who love to gain knowledge. Infraction rules for courts of limited jurisdiction, 2.1a, or IRLJ 2.1a, which reads as follows. Okay? Remember, you can always go to archive.org to be able to get the books that you need. Most of them are on there. Quote, infraction form prescribed or approved by the administrative office of the courts. Infraction cases shall be filed on a form entitled Notice of Infraction, prescribed by the administrative office of the courts. Notice of infraction forms prescribed or approved by the administrative office of the courts are presumed valid and shall not be deemed insufficient by reason of defects or imperfections which do not prejudice substantial rights of the defendant. The preceding citation is found at the bottom of a traffic infraction. Notice all the bottom of the infraction claim form the words Washington Uniform Court Docket. We think that uniform's in relation to, y'all, the Uniform Commercial Code. Why? Because they're a business. This form of infraction, or writ, is a command by the judiciary to the executive department of government, the police, to provide the judiciary with all the jurisdictional information they need to perfect the state's claim. Claim. Everything that happens in a courtroom happens at the discretion of the judge. However, be equally assured that the judge will use that discretion to the best benefit of the state, because as the rule above indicates, an infraction is valid as long as it does not prejudice substantial rights of the defendant. Rights of the defendant. And if you don't know your rights, how are you to invoke principles that will set you free? And a driver's substantive rights will not have been violated because the driver is presumed, again, you are presumed to have the knowledge of the constructive contract or either your rights. They're presuming you should know it. The information's out there, and if you do not, it's not our fault. If you allow us to rule over you and you do as we ask, because that's all they can do is request, because several statutory alternatives for meeting that element were based on conduct alone. The statutory scheme created a strict liability crime requiring no proof of the defendant's intent. State of Washington versus Stephen Mertens. Now you see why we want to pull out that contract. I know there's case law that says, hey man, it kind of everything really matters in relation to the person actually operating the vehicle and how they're operating the vehicle. But man, there's more case law on that. If you stand in your rights, you fully protected. So I'm just gonna do that. I don't need that contract, man. The policy enforcement employee is only enforcing a contract that was made to operate a business. Let's rewind. The policy enforcement employee, your police officers, is only enforcing a contract that was made to operate a business. And the judge is fully cognizant of that contract. The judge is fully aware of that contract. We now know, I have several instances of videos and proof of my own self out here showing, man, that these cops know, y'all. They know. They're sitting here admitting on the camera now, man. I'm asking the lady cop over in Ridgefield while she talking to the chief and Sergeant Duran, who's out here violating people's rights. I go up to her and say, "Are you learning something today?" She said, "I've always been fascinated with sovereign citizens." Why are you fascinated? Why? Why are you fascinated? Because we understand. Well, I'm not a sovereign citizen, but because those who, think a little bit more stand on it. And I said, well, she said, well, explain to me. I explained to her the difference between sovereign and citizen. And then I said, you work for the state, you work for the corporation. She said, I know. I said, yeah, and all of them, you really only have authority on those people who have given consent and signed a contractual agreement with you. And she said, no, I agree. I totally agree. I got another cop saying, no, yeah, I understand, man. You're not driving, you're traveling, you're not doing commerce. Let me go. Traveler plates on my car. VIN covered up. But literally saying here, yeah, you're not sorry. So my thing is, if we know that they know, because we can go and read it in their manual. You can read it in their own. I'm going to stop. I digress. Let's get back to the information. Let's get back to it. I digress. The policy enforcement employee is only enforcing a contract that was made to operate a business, and the judge is fully cognizant of that contract. Here's why. The infraction contains a certification by the police employee that everything is as true. Y'all ready? The undersigned certifies and says that in the state of Washington, your legal person information here, did operate the following vehicle or motor vehicle on a public highway, and your business information here, did and then there commit each of the following offenses, statute violations here. I certify under penalty of perjury. What's up? I love being me. You should love being you, because you are me and I am you and we are us. And that is all part of the great I am. Thanks for being here, bro. Glad to have you here. Bro, if you're a bro. If you're not, sis, On the infraction, there are 3 jurisdictional balloons, 3 of them now. The first balloon contains a person's employee driver's license number, which certifies the person to be the driver. Why do you think they ask for your driver's license so much? Okay. Hey, sis. Hey, sis. I will remember. I guarantee I won't forget. Now, let me see what it says here. It says the first balloon contains a person's employee driver license number, which certifies the person to be a driver. That's why they need that driver's license. That's why it's crack. They need to see the driver's license because they need to find out if you're a person that has a contractual agreement. Ah! It also contains all identifying information about the legal person. It also contains a block for the identity of the employer of the driver. Ah! It also contains several blocks which indicate that the statute violation occurred within the venue jurisdiction of the state of Washington and or the local jurisdiction. Did you give up your rights? Did you sign them away? Did you give away your rights for a privilege? A privilege in which you have given up all of your you've succumbed to the jurisdiction of being under the DMV, being under the Department of Transportation, being under the authoritative police state of the Washington or whatever state you're in. The first balloon gives the court indisputable personam jurisdiction. Ah, there it is. People wanted to go in there and fight with a driver's license, but the court's got personam jurisdiction. Contract, give up your rights. Not me. The second balloon contains all of the business identifiers as far as the DOL. There it goes, Department of Licensing. The DMV, there it goes again, I told y'all. And the DOT are concerned, saving taxing regulations necessary to convince a judge that, in fact, there exists a business for the proprietary jurisdiction of the police and the latent jurisdiction of the court. It contains the business name and the address, as well as the business vehicle identifiers, primarily the license plate number. The license plate number itself is tantamount to a master business license. Oh, didn't you know? Didn't you know? And as such, is a physical address, oh my goodness, as it were, of the business vehicle, much like a street address if the business were located on real property. Occasionally, a policeman will write, same as above, in the owner box. This is because the owner-operator of the business occasionally is driving his own business. The second balloon gives the court the first element of subject matter jurisdiction, being that the business is conducted within the state of Washington, clearly. This third balloon gives the court the second half of subject matter jurisdiction. This balloon calls for the specific statute code section purportedly violated. The box labeled DV is an acronym for domestic violence. Ooh. As for wanting to argue facts, when a person checks the box to request a mitigation or appeal hearing, he is not only equestering that he committed the violation and subsequently wants to negotiate the damages he caused the state, asking for equitable review. He also, in and of his heuristic delusion, has voluntarily, here goes another right that we're giving up because we're volunteering. He has voluntarily given the last element of subject matter jurisdiction, which are now the facts in evidence. Oh man, all totaled, the court has complete and inescapable jurisdiction to uphold the executive decision. Oh, man. Uh-oh. Now we're in trouble. It's a trap. But you put yourself in that trap, right? What's a matter you? Only you can put yourself in that trap, right? Only you can put yourself in that trap. When you ask for permission to use the roads, when you ain't even using the privilege in which the state gave you. How is that possible? Make it make sense to me. Then you have people telling you to give up all of your information as soon as they come to the car. No, Jurisdiction is complete when you the highest of authority, bro. Why you living in fear, bro? 'Cause someone got a gun on the side of their hip? Please. That don't scare me, bruh. Please. That don't scare me. Because the great creator is working through me. And any of you that allow the great creator to work through you, you shall fear none. We ain't scared. We're nice, we're polite, we are kind, we are full of giving everything that we can of ourselves. But I cannot respect someone telling someone to waive their rights. All based on ignorance. Can't do it. Won't do it. Not good. Not good enough. Gotta do better. Gotta do better. You're gonna have to with me because I'm not putting up with it. I'm gonna call it out. Because you're harming my people. You're giving my people false, misleading information. The second balloon contains all of the business identifiers as far as the DOL, DMV, and DOT are concerned, saving tax regulations necessary to convince a judge that in fact there exists a business for the proprietary jurisdiction of the police and the Latin jurisdiction of the court, and contains all the business name and address as well as the business vehicle identifier. We already read this. Yep, domestic violence. Yep. As for wanting to argue with the facts, when a person checks the box to request a mitigation, okay, yep. To uphold, yep, inescapable jurisdiction. Sorry, y'all. Damages. Yes, damages. When a traffic violation is alleged, it is a suspect determination that a driver has disrupted the flow of traffic or caused there to be a potential public risk circumspectly harmful to some other fellow traveler or commercial enterprise. So, in the estimation of the state's regulatory police power, it is deemed suitable to issue a warning, as it were, that the conduct is suspect and that the driver surrendered some consideration of penalty or money intended to be the form of behavioral modification. Oh, we got an example. Let's look at that. Microdata, Olympia, criminal, traffic, non-traffic. Why do you think they got non-traffic on that bad boy? Because traffic is a commercial term? Now, something we're going to point out here, it says in the district or municipal. Whether it's district, that district means county, that municipal means city. If you look within both of your county codes, ordinances, and your municipal, county, or city ordinances, you will find, at least I have found and can't find any others, something very similar to the term under the definition. You got to look in the definitions aspect. Look under county road and tell me, you come back and tell me in the comments whenever you got time, if that bad boy don't say open as a matter of right for public vehicular travel. You tell me. You come back and tell me now. LEA original number right here's court original number here. The undersigned. Then we got information. Did operate following motor vehicle on public highway and did there and commit each of the following offenses: mandatory court, bail forfeiture, complaint or citation. Looking for that uniform. Me personally, myself, I want to see that uniform. Complaint, abstract of judgment. Oh, there it goes. Washington uniform. Under the UCC. Department of Licensing, as though a license, you already know what a license is. It's permission to do something you could not do otherwise, which would be illegal. It can't be illegal to travel on the roads. Like, what? Are you crazy? Tort liability. So the journal discussion below, not intending, I don't know this one. Polemic discourse from the significance of the article has been taken excerpt and edited for content. The journal article is a discussion of the differences between those who are specifically impliedly invited, and those who trespass for want of permission to enter a premises. The article also discusses the liability of tort, or percent thereof, for injury while on those premises with respect to the type of permission granted, implied, or expressed. The article lays out differences between property owners versus lessors of property and their relation to permission given. As a matter of course of and for expurgatory value, there also is told of a right of passage on property. You goddamn right there is. It is the last which the discussion here exemplifies. So as we move through the actual article excerpt, be mindful of the following terms. There is significance in the terms we substitute as we substitute them later. You're exactly right. Words got meaning. It's like that. It's like really quickly. It's like when I had that situation in Richfield and the lieutenant's talking to me before I go, talking to the chief. And she literally tried to say to me, yo, I just want to get the VIN number. All we want to get quick is the VIN number, right? We just want the VIN number. No, you're not getting it. Well, yes, we need it. No, you're not getting it. I'm private. I'm not giving you my VIN number. You're not getting that. Well, you're driving. No, ma'am, I'm not. Explain it. No, yeah, but you're just personally driving. No, ma'am. What you don't understand, the difference between what we use out here in the streets and what we use in the court system, what they use in legalese, what they use in the legislature, what they use. That's why you got definitions before the document. So you know that they're completely different. It's just she tried to trap me 3 times by saying, no, you're just driving. No, you're just normally driving. No, you're just driving. No, ma'am, stop. I see what you're trying to do. It's not going to work here. Entire screen, boom, share. I'm starting to be able to move faster with this now, y'all. I figured out how to do it. All right. Owner, occupier, licensee, defendant, invitee, bearer licensee, visitor, premises, property, dangerous, condition. 63 Yale Law Journal 605. Why does this number always pop up in my life? Rule. Even where the occupier knows of a danger, he owes the licensee no duty of precaution if the danger is perfectly obvious. This rule has sometimes been put as a duty to warn the licensee of a known trap. Who said a trap earlier? What was that? Wasamatu? Who said that earlier? Wasamatu? What did he say? Who said that earlier? I know who said that? It's a trap. Where they say that at? I saw somebody say it. Maybe it was what's the matter you? It's known as a trap. In some of the older cases considered a condition a trap if it was dangerous and very much concealed. Man, you see how these legal principles can really get us into some situations of real civil litigation that we can pursue ourselves with no lawyer. That's what my main focus is here. My main focus here is to be a pro se attorney in fact and teach you everything that I'm going through and that I can find so that you can go out there yourself and file your own complaints without needing to cry in the court. The licensee must show defendants knowledge of a dangerous pitfall, whether it be natural condition or arraignment of premises, or that he made an inspection which would have been likely to disclose the dangerous condition to him. If he shows that defendant created the dangerous condition, which will be suffice. While plaintiff must show defendant's actual knowledge of the condition, defendant will be held to appreciate its danger if a reasonable man would do so. An interesting question is posed if defendant created a condition which was not dangerous at the time, but which would foreseeably become dangerous. There are a good many dicta, mostly in older cases, of course, where they had logic, and some holdings to the effect that the occupier of land owes the bearer licensee no greater duty than to refrain from intentional or willful or wanton misconduct towards him. Quote, once a person's presence becomes known, the significance of the classifications largely disappears, and he is owed the duty of reasonable care as to activities, whatever his status on the land. This does not mean, however, that the plaintiff's status may have no bearing on what conduct defendant may reasonably expect of him, unquote. The occupier is commonly said to owe greater duties to his invitees than to his licensees, notably with respect to inspection and discovery of latent dangers on his land. The economic benefit theory proceeds on the assumption that affirmative obligations are imposed on people only in return for some consideration or benefit. Exactly. Any obligation to discover latent dangerous conditions of the premises is regarded as an affirmative one, and the consideration for imposing it is sought in the economic advantage, actual or potential, either actual or potential, of the plaintiff's visit to the occupier's own interest. It is not the fact of the invitation, nor of the knowledge of the probability of the customer's presence, which this implies, which raises the duty, but the purpose of the visit and the occupier's interest therein. Interest. The invitation test does not deny that invitation may be based on economic benefit, but it does not regard that as essential. Rather, it bases invitation on the fact that the occupier, by his arrangement of the premises or other conduct, has led the entrant to believe that the premises were intended to be used by visitors for the purpose which the entrant was pursuing, and that which such use was not only acquiesced in by the owner or possessor, but that it was in accordance with the intention and design with which the way or place was adapted and prepared. Oh my God. Even an express invitation might not raise such expectations. However, it has been applied particularly when premises were prepared for the public or a segment of it. Oh, I know it's deep. I know it's deep. Quote, a business visitor is a person who is invited or permitted to enter or remain on land in the possession of another for a purpose directly or indirectly connected with business dealings between them. Hopefully that helps some. Okay. To give up a right while using the conveyance. Yes. So, yes. So, quote, when one expressly or by implication invites others to come upon his premises, whether for business or for any other purpose, it is his duty to be reasonably sure that he is not inviting them into danger, and to that end he must exercise ordinarily care and prudence to render the premises reasonably safe for the visit. Mutuality of interest does not mean that there must be a commercial business transaction between the parties, but merely that each party is moved by a lawful purpose or interest in the object and subject matter of the invitation. Oh, the deeper principles are so beautiful. The enterprise must be mutual to the extent that each party is lawfully interested therein, or that there is a common interest or mutual advantage involved. Unquote. In other cases, there has been no arrangement of the premises so as to induce entry, and the significant factor is the economic benefit conferred on the occupier by the visit. This is true of the person summoned to transact business with the occupier, whether the premises be arranged for business. Viewed as indirectly incidental to an economic benefit, it seems much more to the point that such people know that the occupier is required by law to receive them, and so have reason to believe that their coming is anticipated and that the premises are ready for their reception. There is no quote, there is no reason. Hold on, I'm just gonna take a sip. My mouth getting dry. Quote, there is no reasonable distinction between the rights of a person visiting the premises for the purpose of escorting another to a departing train and the rights of one who goes there for the purpose of talking with a departing person on a business matter. There is a wide difference between the use of the premises with such motives, the latter, and those of idle curiosity and merely to kill time. Unquote. These cases can be reasonably explained only by the invitation theory, as can the cases involving an apparent extension of the highway. If a man arranges a part of his land so that it looks like an extension of the public sidewalk or roadway, a traveler who takes it for such is an invitee through his entry onto the private land, confers no benefit whatsoever on its possessor. Now we're getting deep now. We're getting deep now. It makes no difference that a pecuniary profit or other benefit was received or expected by the society. The fact that the plaintiff comes by invitation is enough. Oh, if on the other hand, defendant arranges part of his premises, leading to a visitor reasonably to think that they are included in the area of invitation, he will be led as an inviter as to that part, even though he did not mean to invite the plaintiff to it. Uh-oh. The occupier's duty to the invitee. Here we go. The occupier's duty to the invitee, to you and me and everybody else, is one of due care under all circumstances. If plaintiff is an invitee at the time and place of his injury, the occupier, of course, owes him all the duties he owes to trespassers and licensees. Excuse me. Thus, the occupier must use care not to injure plaintiff by negligent activity. In addition, the occupier owes the duty of care to inspect his premises and to discover dangerous conditions. This is the most prominent difference between the rights of invitees and those of licensees. The occupier need not invite visitors. And if he does, he may condition the invitation on any terms he chooses, so long as there's full disclosure of them. The occupier need not to invite visitors. And if he does, he may condition the invitation on any terms he chooses, so long as there is full disclosure. Have you and I been given full disclosure? Oh, boy, y'all better get down to it. If the invitee wishes to come on those terms, he assumes the risk. But here again, the basis of defendant's truncated duty is not his superior knowledge, but his ownership and control of the reasonably dangerous condition. Oh, so even if he wasn't superiorly knowing, it only really boils down to his ownership and control in a reasonable manner without being dangerous on the roads. So it has to be both and or. Is it and or is it and or? Under this rule, the occupier's superior knowledge might properly be called a condition of liability, but it is not. It is not. It is not a reason or justification either for the occupier's duty or for the limitation put upon it. Defendants claimed that its only duty was to warn, but the court answered that it did not recognize it to be a universal rule that an owner who invites the public upon his premises for business or pleasure may, in the absence of reasonable necessity, maintain thereon dangerous agencies as wires charged with deadly currents of electricity in such places as to endanger life and limb, and to escape liability by maintaining danger signals or otherwise advising the public. In cases where the invitee's recovery has been denied, contributory negligence has often played an important role and is sometimes hopelessly confused with the duty issue. If contributory negligence would always bar an invitee who was injured by a condition of the premises with which he knew and appreciated, the confusion would do little practical harm. Most decisions denying liability are rested equally on the ground of contributory negligence. Curtis versus Traders National Bank, 314 KY 765 237 SW 2D76. These situations show that the invitee will not always be barred by his self-exposure to known dangers on the premises. This means that the restatement rule remember this, restatement rule will sometimes bar a plaintiff who has not been negligent from recovery against a defendant who has acquainted the plaintiff with the condition which would be negligent towards him if a full duty of care were owed. A right to enter also stands on a footing different from the privilege which the occupier is free to withhold or to give by invitation or permission. This does not mean that visitors in their own right should all be accorded to the same treatment. Thank you. I appreciate that. They are not, and probably should not be. Rather, it casts further doubt on the utility of the present system of fairly rigid classifications. Oh, I know it's a deep one. I know it's a deep one, but it's meant to be. Got to get down to the principles. So, in this latter interpretive discussion, for the purposes of this section, the following terms used in the journal are given accord, though still very much within the parameters of the scope of this actual journal discussion that we just read. The terms are augmented to give a veracity to this discussion. So now we're going to break down what we just read. The term plaintiff will not be affected because the non-business traveler, now armed with absolute knowledge, you and I and everyone here that continues to watch after, would be the injured plaintiff. When reading this version, Take care to notice the journal terms have been replaced with terms applicable to this topic and yet remains completely wholly in context. Journal terms and substitute. Owner, public, occupier, uh, licensee, defendant, state. So we have state, licensee, business. So your occupier is the state. Your licensee is the licensee, which is the business. Your invitee is traveler. Looks as though the defendant is the state. It seems like this should go here. Yeah, because public's there. Owner, public. So owner, public, occupier, state, licensee, defendant, state, invitee is a traveler, bar licensee is a traveler, visitor is a traveler, premises is the highways or roads, including your county roads, property, which is the highways or roads, dangerous is business, condition is license. Okay, got to take another sip before we get going. Y'all quiet down there in them comments today. Y'all quiet in them comments today. That means you're retaining. You ain't even trying to say nothing. You're like, man, this knowledge is deep. Yeah, it's deep. That's why it's great. That's why it's the advanced course. Yeah, absorbing for sure. This is good stuff. So the rule, okay? Even where the state knows of a business, the state owes the business or licensee no duty of precaution if the business is perfectly obvious. This rule has sometimes been put as a duty to warn the business of a known trap, and some older cases considered a license a trap. If it was business and very much concealed, the business or licensee must show state's knowledge of a business pitfall, whether it be naturally occurring or a specific arrangement of highways or roads, or that he made an inspection which would have been likely to disclose the business license to him. If he shows that the state created the business license, that will suffice. While plaintiff must show state's actual knowledge of the license, the state will be held to appreciate its business if a reasonable man would do so. An interesting question is posed if the state created a license which was not business at the time, but which would forcibly become business. There are a good many dicta, mostly older cases, and some holding to the effect that the state owes the traveler no greater duty than to refrain from intentional or willful, wanton misconduct towards him. Now you get how deep it is when we switch around those definitions. Now you start to see. There are many good dicta and case law, and mostly older cases, and some holdings to the effect that the state owes the traveler, me and you, that person of all high authority, no greater duty. There is none greater duty that any of these state agencies can do and owe to us, or us being travelers, to refrain, meaning leave us alone. This document is the link for the description, or the link for this document is in the description of this video. Okay, it's in the right to travel course. You got to sign up for it on the website, y'all. All the documents are there. Or willful or wanton, it's free. Okay, misconduct towards him. Once a person's presence becomes known, the significance of the classification largely disappears. Once a person's presence becomes known, once it is known that I am a traveler, the significance of the classifications largely disappears, and he is owed the duty of reasonable care, meaning that you are to respect and honor me. As to the activities, whatever his status is on the land. This does not mean, however, that the plaintiff's status may have no bearing on what conduct the state may reasonably expect of him. The state is commonly said to owe greater duties to its travelers. Oh, my Jesus. It owes more duties to me. All you state agencies, I'm going to read this to you straight up. The state is commonly said to owe greater duties to its travelers than to its licensee businesses, notably with respect to inspection. This is a Yale writing now. Law Journal. Don't get it wrong. This isn't my words. These are people that, on a knowledge aspect, have a greater sense of how this works. I promise you that. Let's trust them in the matter. Notably with respect to inspection and discovery of latent business on the land. The economic benefit theory proceeds on the assumption that affirmative obligations are imposed on people only in return for some consideration or benefit. Any obligation to discover latent business licensee of the highway roads is regarded as an affirmative one, and that the consideration for imposing it is sought in the economic advantage, actual or potential, of the plaintiff's visit to the state's own interest. Okay, I'm going to read that was to you. If you don't get it, rewind it, try it one more time, and we'll come back to it if we need to. It's okay. We're here to learn together. Don't you understand that everything that we're trying to do is in unity? We want to bridge the gap, bro. It's all comes on knowledge, and I think we can do it. Quote, it is not the fact of invitation, nor of the knowledge of the probability of the customer's presence which this implies, which raises the duty, but the purpose of the visit. The purpose of the visit. Purpose, the intention, how I was conducting myself, and the state's interest thereon. Well, I know you can't have an interest in my own private travels. There can be no interest there that you may have. Right, state? The invitation test does not deny that invitation may be based on economic benefit. Exactly. But it does not regard that as essential. Clearly, rather, it bases invitation on the fact that the state, by his arrangement of the roads and highways, or other conduct has led the entrant to believe that the roads or highways were intended to be used by visitors, travelers, for the purpose which his entrant was pursuing, and that such use was not only acquiesced in by the public or possessor, but that it was in accordance with the intention and design with which the way or place was adapted and prepared. It was prepared and adapted for us. What you mean, man? Even an express invitation might not raise such expectations. However, it has been applied particularly when highways and roads were prepared for the public or a segment of it. They were always made for us. The whole intent of the initiation of the roads were for the public. And then the invitation test does not deny that the invitation may be based on economic benefit alone, but that it does not regard it as an essential one. That's why you got to understand the difference between public roads and tollways. Hello? Hello? A business visitor, quote, a business visitor is a person who is invited or permitted to enter or remain on land in the possession of another for the purpose indirectly or indirectly connected with business dealings between them. Quote, when one expressly or by implication invites others to come on upon his highways or roads for whatever business or for any other purpose, it is his duty to be reasonably sure that he is not inviting them into business. And to that end, he must exercise ordinarily care and prudence to render that those highways and roads reasonably be safe for the visit. Mutually of interest does not mean that there must be a commercial business transaction between the parties, but merely that each party is moved by a lawful purpose or interest in the object and subject matter of the invitation itself. The enterprise must be mutual to the extent that each party is lawfully interested therein, or that there is a common interest or mutual advantage involved. In other cases, there has been no arrangement of the highways or roads so as to induce entry, and the significant factor is the economic benefit conferred on the state by the visit. This is true of the person summoned to transact business with the state, whether the highways or roads be arranged for business. Viewed as indirectly incidental to an economic benefit, it seems much more to the point that such people know that the state is required by law to receive them, and so have reason to believe that their coming is anticipated, and that the highways and roads are ready for their reception. Again, there is no reasonable distinction between the rights of a person visiting the premises for the purpose of escorting another to a departing train and the rights of one who goes there for the purpose of talking with a departing person on a business matter. There is a wide difference between the use of the premises with such motives, the latter, and those of idle curiosity and merely to kill time, the former. These cases can be reasonably explained only by the invitation theory, as can the cases involving an apparent extension of the highway. If a man arranges part of his land so that it looks like an extension of the public sidewalk or roadway, a traveler who takes it for such is an invitee through his entry onto the private land. Confers no benefit whatever on its possessor. It makes no difference that no pecuniary profit or other benefit was received or expected by the society. The fact that the plaintiff comes by invitation is enough. If, on the other hand, State arranges part of the highways or roads, leading a traveler reasonably to think they are included in the area of invitation. He will be held as an inviter as to that part, even though he did not mean to invite the plaintiff to it. The state's duty to the traveler is one of due care under all circumstances. If plaintiff is a traveler at the time and place of his injury, the state, of course, owes him all the duties he owes to the trespassers and licensee business. If a plaintiff is a traveler at the time and place of his injury, the state, of course, owes him all the duties he owes to the trespassers and licensee business. Thus, the state must use care not to injure the plaintiff by negligent activity. In addition, the state owes the duty of care to inspect the highways and to discover business licenses. Not to us. This is the most prominent difference between the rights of travelers and those of licensees. And it's amazing what we get to understand when we look at these deeper aspects. The state need not invite travelers, and if he does, he may license the invitations on any terms he chooses, so long as there is full disclosure of them. If the traveler wishes to come on those terms, he assumes the risk. You want to assume those risks there, buddy? I don't. But but here again, the basis of state's truncated duty is not its superior knowledge, but its ownership and control of the business license. Under this rule, the state's superior knowledge might properly be an assumption of liability, but it is not a reason or justification either for the state's duty or for the limitation put upon it. Defendants claimed that its only duty was to warn, but the court answered that it did not recognize it to be a universal rule that an owner who invites the public upon his premises for business or pleasure may, in the absence of reasonable necessity, maintain their own dangerous agencies, as wires charged with deadly currents of electricity, in such places as to endanger life and limb, and escape liability for maintaining danger signals or otherwise advising the public. In cases where the traveler's recovery has been denied, contributory negligence has often played an important role and is sometimes hopelessly confused with the duty issue. If contributory negligence would always bar a traveler who was injured by a license of the highway roads, which he knew and appreciated, the confusion would do little practical harm. Most of the decisions denying liability are rested equally on the ground of contributory negligence. These situations show that the traveler will not always be barred by his self-exposure to known businesses on the premises. This means that the restatement rule will sometimes bar a plaintiff who has not been negligent from recovery against the state, who has acquainted the plaintiff with the license, which would be negligent towards him if a full duty of care were owed. A right to enter also stands on a footing different from the privilege which the state is free to withhold or to give by invitation or permission. This does not mean that the travelers in their own right should all be accorded the same treatment. They are not, and probably should not be. Rather, it casts further doubt on the utility of the present system of fairly rigged classifications. What does all this mean? You're as confused as me. What does all this mean? Deepest of principalities. What does all this mean? What does all this mean? Are you confused as me? Are you confused as me? So let's get it, my dude. We. What does all this mean? It means that the state should take caution to warn travelers that an application for a driver's license or an operator's license moves the traveler from a free use category to a full-time regulated business category. Conversely, a traveler has an obligation to make his non-business present known to the state. What? What? Notice of liability? No. The state owes a duty of full disclosure as to the distinction purpose of. The state, it says, owes a duty. The state owes a duty of full disclosure as to the distinction, purpose of, and use for the application for driver or operator's license. when that free use traveler distinction is made, the several classifications of motor vehicles and motor vehicles becomes what? Entirely irrelevant. Why? Because all of it is null and void. Null and void. The state's regulatory authority stops predominantly, not entirely, at the regulation of businesses. The state has a duty to protect all of its travelers as members of the general public, all the while it is surveying the roadways, affecting its business regulatory police powers. Y'all, some of y'all took that police power to go way outside of what it was wrote up to be. Y'all need to go read that statute. You heard police powers and you just thought it was a blanket across the whole platform of everything in existence. No, sir. That police power is very limited. And if, let's make a quick and if real quick. And if the legislator and the legislation is not very precise, then all we got to do is invoke the rule of lenity when we get in that courtroom, because we were not given notice, which again is a violation of due process, because the rule of lenity, a principle in court, requires that it stay within the statutory framework of what was defined in the statute. If it's not defined, it can't be applied. We are learning how to operate now on all capacities, not just in the car with the Eddie Craig script, but in court as well, while never giving up any right. Not one. We are waiving nothing. We don't consent, bruh. We don't consent. We don't consent, man. Licenses are for the conduct of businesses and commerce, and the private traveler cannot be forced by attrition to relinquish or surrender his God-given fundamental most sacred liberties or common law access to the highways for some license to engage in some business that he isn't even pursuing. The state has an obligation to allow private use of the highways. The state has an obligation to allow private use of the highways. I told y'all, go to your county code right now and look up the definition of county road. Go to your city or municipal county code right now on ordinances and look up the definition in your city's code of county road. And tell me if it don't say as open as a matter of right to the public and their vehicular travel. Please tell me different. When a policeman stops a traveler, he is trespassing, creating a private nuisance. When a police officer stops a traveler, he is trespassing, creating a private nuisance. Guess what, y'all? You can go right now and put private plates on your car and put a card in front of your VIN, and you are now a private traveler. Who is going to know any information about you? Put a plate on that says not for hire. Traveler. Public vehicular traveler. Go to the Eddie Craig script. Follow it precisely. And if they violate you, oh boy, you got your suit right there. Y'all want to talk about First Amendment audits? Get in your car and do car amendment audits. Whatever numbers though are, because it's quite a few amendments that be getting violated when you're out there in that car. If the policeman issues a traffic infraction, he creates an aggravation of circumstance. Although the infraction is tantamount to a solicitation and thusly an invitation to engage in a secured transaction, saving elaboration. You see what I was talking about on that UCC? I told y'all it gets deep. They all have to, all of these corporations and municipal courts, all of these states and all the corporations have to follow UCC law. We're not going to go there yet. We'll get into UCC soon. I need to get through this first. Offering an opportunity to the traveler to submit the state to state jurisdiction and or admit that someone was actually driving a business. They need the driver's license to establish jurisdiction. If they can't get it and they force or try to force by breaking window shields and doing all of their intimidation, you will be protected in your safe conduct because you are operating outside of their jurisdiction. It's null and void. Anything that they try to say is null and void, especially if you're driving in safe conduct. If they are inquiring you only due to the fact that you have not for hire traveler plates on, and they thereby try to force you to do anything, you are protected 100%. Oh, my eye's starting to twitch. That shit's annoying. I hate that. So we're going to go on a smoke break right here, real quick. I'm going to spark up. I want to see what y'all got to say in the comments real quick. What's up, Irish folk? What's up, Theo? Hey, Becca. What are y'all thinking about this so far? This one's a great... I told you we're going into the anatomy now. The anatomy. It's a big one. Express or implied permission from the owner, but not by other members of the public. Express or implied permission from the owner, but not by other members of the public. Consent? We do not consent. There must be consent. Bro, I cannot smoke this without coughing. This stuff is so strong, bro. I try so hard not to. If you're in Washington, Plaid Jacket got some really good stuff, bro. This is some permanent marker. I know of permanent marker only because I've dealt with Archive, the seed company in Portland. They made a really big lineup for Jungle Boys, and they still continuously do. Jungle Boys down in Los Angeles. Shout out Jungle Boys. Y'all know who I am. All right, so that Otolo Organics. Otolo Organics. You ever want to look up my past? All you got to do is look up Otolo Organics. Yeah, man. Growing lots of weed. Maybe we'll talk about that, share that story sometime. Okay. So, the nuisance theory. Oh, let me get back over the screen. Sorry, y'all. My bad. Entire screen. Boom, boom. I hate it when it just does that to me, but whatever. Now, the nuisance theory is reciprocal. It is this nuisance post-trespass, which post-trespass, okay? Why you think I'll be out there filing my notice of liability? Because it's a post-trespass. You got to give notice, y'all. You got to put them on notice. Then if you put them on notice and they still harass you, this is where we're getting into right now, okay? Which creates the tort liability of John Doe policemen. The chief who accepts your notice of liability, okay? So if I wanted to, even though they've gone on to a new chief in Ridgefield, because he accepted this notice of liability, I can go after him in his individual capacity as well, because I put him on notice. And still, they trespassed, which creates a tort liability of not only the police department and the police departments or the police officers who were on site and those who were in conjunction with the violation and harassment, but also those who accepted my notice and did not make sure that that trespass didn't occur. David Large says, everything you have given to we the people has been fired. We have to get to the knowledge. It's not me that's given this. It's people that come before me, man. I just don't understand why people haven't been given the deeper knowledge in the first place and have been selling things to them that are going to, that literally gives up and waives their rights, that gives the court's jurisdiction to operate over them. There are literally people teaching other people and telling them to buy things from them that literally put them and that dig their own grave. That is phenomenal to me. The fact that John Doe, policeman, has impeded the ability to travel. He is the very epitome of obstruction. Y'all gotta start understanding you are a free living being, bro. You cannot be forced or told to be done anything. Black's Law's Dictionary defines nuisance as nuisance. I love that word, nuisance. A condition or situation that interferes with the use or enjoyment of property, life, liberty, and the enjoyment of happiness. A nuisance is a state of affairs. To conduct a nuisance is a tort. Quote, the right of the public in common highway is a paramount, and the right of the public in a common highway is a paramount in controlling. Paramount, 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 paramount. This right extends to the entire territory within its limits, and an obstruction placed upon any part of it constitutes a public nuisance. A nuisance is a tort. A tort. A tort. Why are you not filing tort claims? Why are you allowing them to take you to the court and be put in their personam jurisdiction? Because we don't have the knowledge. We don't have the knowledge. We have to have the knowledge. The knowledge is all the power that you need. Commonwealth versus King. The law applied to motor vehicles. Babbitt, 1911, citing Morton versus Moore. You see how frustrated I get? Do you see how deep this gets? Do you see how much it hurts my heart and frustrates me? Do you see why I have to call out people? I don't want to be mean. I don't want to be rude. I want to have a beautiful conversation and uplift and get this traffic law reform, decriminalization spread throughout the nation. I'm tired of people dying over this crap, man. I'm tired of people getting their property taken away from them, bro. I'm tired of people getting their things stolen from them. I'm tired of their energy going towards theft, bro. I'm tired of it. It's not cool. It's not right. It's unfair. It's not what our nation was built on. And it's all based on ignorance. And we have to stop it now. Not tomorrow. Now, bro. Our police officers don't even want to do this no more, bro. That's how serious it is. Our police officers don't even want to enforce these crazy stipulations on the public. But they have to meet a quota. They have to stay in line. Bro, I'm not going to be that person that's going to sit here and be like, I hate all police and all police are bad. I'm not. I am going to instill what I want to see out of our police force. And if you can't do what we're requesting in a nice, polite manner to try to build bridge and gap so that we can bring unity to our public and go after those who are scumbags. Because we want everything to be fair, cordial, with upfront honesty and integrity and morale. That's what we need. We need people that are going to stand up for wrongs all the way. Man, I could see, like Jason Lee could have done it all the way. Look, y'all need to stop this. This is going to be tantamount to conspiracy against rights, y'all. Y'all over here telling y'all going to give him a felony for forgery when he's not committing forgery. Y'all need to stop. We need unity in this nation. We need us to come back and understand we are all one. We need the great creator to be at the forefront. They have literally, that's why they are killing that understanding and knowing. I don't care what religion you're in, but they're killing that understanding of knowing so that we all treat each other as one again. Like, you got to remember, you've been here before, you're going to be here again. This is a reoccurring thing that ever lasts and never stops. There is no past. There is no future. It is always right now. And it has always existed. It's like beyond anything we can fathom. I understand there's got to be, for us to even understand what darkness, what light is, there has to be darkness. I understand that. I get it. But at the same time, we know now what darkness is. So can we get ourselves up out of that by just being better and treating each other better? Because if we do that, I swear this place is going to be amazing. We got technology coming in that's going to blow us up. We got that's going to allow a lot of the robots to do a lot of work for us. We got a real potential here to make a beautiful society. And we can really create some beautiful things if we keep the great creator God, whatever you call it, at the forefront. And then knowing that we are all one. And your family could have been black 200 years ago and you don't even really know it. You see what I'm saying? Because we go through waves. We're all one. So let's just end that racist stuff. Because you, my brother, you are my distant cousin. You are my family member. And let's just go into a society of enlightenment, because I can't see anything else for my children, bro. I just can't. I can't. We have to save it now. We have to save it now, bro. Like right now. Right now. If I'm going to do it, do I get into some office, or do we just lead the nation with what we have currently going on with traffic law reform? How do we do it? How do we become the most effective to bring change? Do we just go from state to state to decriminalize the laws like Nevada as far as traffic reform? Is that the ultimate start? Can we get the traffic law reform petition to 1,000 so that way we can start presenting this for real? So that we can start traveling and bringing this on public avenues? Like, where do we start? Where do I go? What do I do? What do we do? I've started this petition. It's growing. I believe it's over 500 signatures, but we need more than that. How do we get it to grow? That's what I need to know. I need to go on more panels. I guess I need to go on more shows. What do I do? Y'all let me know. I'm going to leave it at that one on this one today. What about Michigan? Let me look up. We are in an abusive relationship with the government. It's not fair whatsoever. No, I don't want to say it's abusive. I want to say, again, we can't blame anybody else. We cannot blame anybody else. We have to look within ourselves. We can't blame anybody else. Can't blame us. The information's out there. Okay, we need to blame our parents. We need to blame our grandparents. Just like, you know what I'm saying? Like that's I think we need to take responsibility for ourselves, not being ignorant, because I've been ignorant. And it's okay. We're learning, we're growing, we're becoming better. We find out that they ain't doing us right and we still here doing what they want. Again, we're doing it to ourselves, Becca. We can't blame nobody but ourselves. I understand, but what you are missing is that most folks don't want to possess the wherewithal to be free. So they are best off using a trifold and play the game as best they can. I agree, though. It hurts my heart. It hurts my heart to see another have to pay up when they don't have to. That's my biggest thing. They don't have to. It's just standing on your rights. It's not hard. If you're gonna go to Costco today, take off those plates. Go buy you some on Amazon. It says not for hire, traveler. Cover up your VIN. They can't do nothing. Nothing. They come up to you. It's like those guys that go to those stops. Those guys that go to those what are they? I don't know. They're stops by the state. And they do them in Texas and stuff. They're just roadway stops. Citizenship stops, right? They're out here doing citizen stops. And someone sent me a video, posted a link, and I went over and watched it. I watched it at about like 2 times speed. And homeboy just sits there. He don't say nothing. He's like, I'm not speaking to y'all. I'm not talking to y'all. He's just like, not talking. Won't answer him. They gave him a little bit of hassle. But what they say, all right, go on, sir. You're good to go. Like, that's the point where I'm about to get at. The minimum I'm going to do is exactly like the Eddie Craig scripts in my glove box. I will never deviate from it. Shout out Eddie Craig, the godfather of the right to travel in my generation. Shout out Eddie Craig and the law of Tao, or Tao of law. Shout out Eddie Craig. Y'all put some Eddie Craigs in the chat. Y'all throw some ones in the chat real quick for Eddie Craig, man. Y'all show some love, man, because I'm supposed to be getting them on here soon. Y'all throw some ones in the chat for my boy Eddie Craig, please. To me, that is the godfather of the right to travel in my aspect, who I've learned so much from as far as how to operate. Please throw some ones in the chat for Eddie Craig, y'all. Please throw some ones in the chat, please. And what I think is that I understand people, Got to get to where we're getting at. That's why we have it in stages on this channel. The Right to Travel course is free. This is an advanced series on your sacred liberties, right? Your right to travel, right to locomotion. And my thing is just, if someone's going to say that they're a constitutional scholar, they need to really get down to teaching the Constitution and the laws rather than just telling people to give up, because there should be no giving up of any of your rights. You should never waive your rights. You should always stand on them, because if you waive them, you're disrespecting literally, you're disrespecting the millions of people that have died for us, bro. You're disrespecting our ancestors. Just by waiving your rights is disrespect to the millions of people that died for you to have them. That is major to me. That is major. Millions of people died for you to stand in your rights, and you just gonna waive them because someone wants to put you in fear, and it's all based on ignorance and not having the knowledge. But that ignorance isn't anything that you should be afraid of, because I'm ignorant of a lot of things. I learn every day. I learn every day from my clients. I learn every day from my children. I learn every day from my significant other. I learn every day from y'all's experiences in the comments. I learn from all these emails that you send me in relation to how I can help people using Operation Wise Dome. I learn from people's situations when they're sending me their transcripts, their phone calls, their texts. I work non-stop to empower anybody and everybody that I can. Don't ask a dime for it. And I never will. Maybe, I guess, for books, stuff like that. Can't I ask for something like that? But I think the most greatest thing that you can ever do in this life is to show gratitude to the great creator by empowering his perspectives of himself. I know that every one of you has a spark of God within you, and you are powered by God. You are powered by the essence and ether of God. This code is all throughout this reality. This code is all throughout this reality. Okay? You can't stop it. That code is there. It is ever existent and always will be, and it operates on many functionalities. Just like our ancient ancestors here in North America, Central and South America, with all the gods, were understandings and personifications of what later transpired in Rome and Greece. All personifications of the elements of what makes this realm work. Understanding that source code, the gods. By understanding the source code, I know that there is a spark of the great creator in every one of you. That's why I say, I am you and you are we and we are us, all a part of the great I am, because all of this is the great I am. And I can find no better service to honor and show thanks and gratitude to the great creator than by empowering knowledge and wisdom. Can't think of another way. And if you can, I sure would appreciate you tell me so that I can get myself out of ignorance and improve by doing so. Leave one in the comment for me so I can be better. I love you. Peace and blessings, y'all.